you start your meeting, you have to stop it from.
All right, 55th Circuit Court is now in session. The Honorable Roy G. Meek presiding. May be seated. Okay, in the case of Kimberly Lynn Hagan Terracino versus Stephanie Dennis, counsel identify for the record, please.
Karen Tomczyk for Ms. Dennis.
And Ms. Terracino, you're not represented by anyone, is that correct?
That is correct.
And you are Kimberly Hagan?
Yes, Kimberly Hagan Terracino.
All right. Would Ms. Dennis and Ms. Hagan Terracino both raise their right hands and be sworn?
Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
I didn't hear, did both of you answer yes?
Yes.
Okay, all right. Any preliminary matters, Ms. Tomczyk? Any discussion you want to have?
No discussion, Your Honor, other than the fact that I know there's a third violation out there. I don't know if this would be more prudent to hold everything on the same day or not.
No, I don't think so.
Okay.
Not at this point. All right. Okay. I'm just going to refer to you as Ms. Hagan, okay? You filed these motions to show cause for violation of personal protection order. The first motion for show cause alleges that Ms. Dennis contacted you on or about March 28th, March 30th, April 3rd, and April 6th by texting you. Is that correct?
Yes, Your Honor.
All right. And then the second motion in order says that she texted you again on April 8th.
Yes.
All right. And then why don't you tell the court about those texts?
Stephanie began texting. At first, we didn't know it was Stephanie. Just her random normal text that she would normally do, pretending like she's somebody else. And then we started seeing clues in there that was showing that it was her. She calls herself Harley Quinn. Seems to call herself Eric seems to be her Joker. That's how she refers to herself. That's how she's referred to herself for a year and a half. And many of the violations, if we were to look back at the text messages, they resemble the same as this. At that point, when we figured it was her, I mean, it was all hours of the night. I immediately called law enforcement. They had checked into the phone number. It was confirmed it was her text now number. Police report was made. It was sent to Clare County. I was told that I needed to go file motions. She then continued again. So I filed another police report and filed another motion with you guys. I also contacted her probation officer that also confirmed the number. And she was also putting that.
I'm going to object as to this confirmation of the number. That's hearsay.
Court will sustain the objection. Other than your confirmation from the police and the probation officer, did you get anything in writing or anything from somebody showing that it was her phone number?
No.
All right. And did you subpoena any witnesses to verify that it's her phone number?
I did not.
All right. And
Immediately when I called her out on it being her, the messages stopped. And then it changed to another different text now number, and she started again, and I have not filed on those ones. I figured 3 would be sufficient.
Okay. And you supplied a printout of the texts. The first
Yeah.
one on April 3rd was at 4 o'clock in the afternoon. The one on April 6th was around 2:30 in the afternoon. The one on Thursday, the April 8th, was 4:30 in the morning. And then 6:40 in the morning.
Your Honor, if I could have a minute and make sure I have those.
All right.
I want to, the court is referencing a April 3rd, right? That's about halfway down on the screenshot. Your Honor, is that?
It was attached to the petition. Those were the, then there's attached to the other petition, one that shows a printout of texts that were on March 28th, March 30th.
Okay, so yeah, they do overlap some, Your Honor. I'm sorry, that's what that's.
And that one also had the April 3rd one on it and the April 6th on that one also.
Okay, yep, okay, I have those, Your Honor.
All right.
I mean,
Go ahead.
Your Honor, you can see the repeated behavior. Even without her mentioning that it's her, she's had multiple PPO violations of the same thing with the same number. When you tell somebody they got the wrong number, they don't continue to text for days and days, all hours of the night, asking you to run away and be happy, to finally be happy together. This continued. It continued until she was called out on who she was, and then it just suddenly vanished and disappeared.
And anything else you wish to say?
No, other than this is just, it just continues and continues, and then she cries and about how sorry she is and she's learned her lesson, but no, she's not learning her lesson. Nothing is being taught to her. She was supposed to report to jail on the last PPO violation and ran for a month while smoking meth.
Your Honor, I'm going to object to the lack of personal knowledge.
You're objecting to what again? I didn't hear all that.
Well, I'm going to object to the lack of personal knowledge and relevancy.
Not lack of personal knowledge when I just sat at her court hearing because she's on probation for violating and for assaulting my husband.
I object.
All right. The court's going to overrule all the objections in this area and take it for what is said, and under the circumstances involved. All right, Ms. Tomczyk, any questions for this witness?
Yes. Ms. Terracino, you indicate, at least I'm going to start with the latest or the first date, that there was a text to a cell phone number on March 28th.
Yep.
Okay. And that was just a hello, and there was no response from your side?
Not till March 30th.
Okay. And that's just a phone number, right? You don't, there's no, it's not like that's a contact saved in your phone?
Absolutely not.
Okay. And the response then, 2 days later, the person responded, "Who is this?"
Yep.
Okay. And then that person gave their name.
No, the response was, who is this? The person didn't give their name
And then, well,
until later on.
okay. So about one text later, they gave their name. Right?
After asking me who I am, you texted my phone.
Okay. And actually, after they gave their name, the response on the other end or your end would have been, "This is ET."
Yep.
Are you ET?
That was my husband's response because we share a phone. ET is my husband, Eric Terracino.
Okay, so you and your husband share a phone.
We do, and he's covered under my PPO.
Oh,
That may be
The
debatable.
judge covered him under the PPO. She's to have no contact with him. She's not to contact him. That's in the
Not
PPO.
under this PPO, it's not covered.
Do what? No, he's
He
covered.
is not covered under this PPO. If there's a separate PPO, he may be covered under that one, but he's probably covered under the district court probation order.
So when
Okay, so clarification, he's not covered with this PPO.
so you gave him a separate PPO then?
If there is one, I don't know. I remember that he filed for one. I may gave it, but this is this case. You're filing under this case. You didn't
Right.
file under the other case.
When I filed for the new PPO, I put in there for him to be covered under mine, and you granted that.
I usually don't issue PPOs that cover more than one person. All right? Because the PPO is a personal protection order. It's not a group protection order. All right? So if you want to cover more than one person, you have to file separate PPOs. So I just want to clarify that. He is not covered under this PPO. He may be covered under something else. I don't know what it is, but today we're here on your PPO.
Okay,
And you've already stated that this is a shared phone, so it's your phone also.
correct. And it's under my name as well.
All right. You may proceed, Ms. Tomczyk.
All right, and it was actually your side of the conversation that initiated the Harley or Harley Quinn conversation?
Yes, because that was to draw out who it was.
Okay, and that person actually indicated that the only Harley they know is Quinn, and sorry for the inconvenience.
Well, what day we on?
It would still be March 30th at about. I'm gonna say-
Exactly. The only Harley she knows is Quinn, and she goes by Harley Quinn. So she gave herself away right there and then. So yeah, you're right. You just pointed that out. Thank you.
Okay, so, but the only it says the only Harley I know is Quinn. Sorry for the inconvenience.
Yeah, your Harley. She then writes afterwards. Do you see that?
Okay. And then your response, or at least the response on the other side, is more of a Joker fan myself.
Yeah, because she refers to Eric as her Joker.
Okay. And then the response you get back is, okay, sir, well, I didn't know, or I didn't have a clue, or I don't have a clue what you're talking about. Sorry for the inconvenience. Have a good day.
Yep, that's what she wrote. And then on April 3rd, so if she has no idea who this is, and it's the wrong number, why does she then continue the following day? And then a couple days later, now is your only chance. Let's run away and be happy. So why does it continue?
Well, ma'am, I'm asking the questions right now.
Okay,
Okay, so it's not for a couple of days later that there's then a response. You go from March 30th to April 3rd. That'll be a couple of days later. There's a response.
yep. And then it goes to April 3rd, and then it goes to April 6th.
And that is asking for someone to give him a hand with the truck.
Yep,
Okay. And then there is this weird text about Now's our only chance to run away and be happy.
Mm-hmm.
You indicated that in your motion and affidavit that you signed, you said that the phone number was confirmed with the Clare County Court. What court and who did you confirm that with?
I spoke with the probation officer.
Okay, so you didn't actually confirm it with the court, it was the probation officer.
Yes, I immediately had contacted the probation officer after Isabella County Police Department had confirmed the number. That is when I contacted her probation officer.
But again, I'm asking, you wrote confirmed by the Clare County Court. That was confirmed by.
Okay, I do believe probation department is the courts,
Okay, that's all I'm trying to get at.
but the messages didn't stop at the 6th. They then continued on April 8th.
I understand, and you've testified to that. And at no time do those text messages ask about you.
They don't need to ask about me. It's my phone she's texting.
At any time did those text messages ask about you.
No, they didn't need to.
Okay.
She's not allowed to contact me.
I have no further questions, Your Honor.
All right. Anything further, Ms. Hagan, in rebuttal?
Yeah. At this point, Your Honor, she's putting a huge strain on my family. She's putting a huge strain on my children. My husband and I, during the,
To object, this has nothing to do with the actual violation. This would be more of a closing statement.
Well, it still continues, whether or not it's considered harassment. So yes, it's relevant. So
you
she-
know,
So the question, and Ms. Hagan, you feel that this is harassment, is that correct?
yes, it is harassment. It's putting anxiety on my family. It's putting a lot of stress and strain. You know, during this time, my whole family was sick with the COVID. We have full custody of her children.
Well, I
We
object to
also-
that. I object to that. You do not have full custody of my kids.
Stephanie.
We have full physical custody of the kids. That was awarded just 2 days ago for full custody. She gets every other weekend. We were all going through the COVID. I'm currently going through with my terminal cancer son, who is now having seizures and serious reactions, as well as my stepdaughter, Raylyn, who's having some serious reactions from the COVID. She's got rashes all over her body. In mental health, it is affecting our whole family. This cannot continue. There is a huge issue. with
Okay, all right, I've heard enough on that. Ms. Tomczyk, do you wish to inquire with your client?
Your Honor, I probably only have one question for my client.
Go ahead.
So, Ms. Dennis, have you ever had the phone number of 1-989-314-1732?
I had it when I first got out of jail the last time, but it was like for a week and that was it. My phone number got switched to 931-0012. That is, I can give you all my phone records.
Okay, and so you had that number for a week. How did you have that number?
It was through a Text Now app that I had downloaded when I got out of jail the first time because I did not have a phone. But all my belongings got stolen.
Can you explain to the court on a Text Now app, how does that work? Do you always have the same number? Can it change?
No, they change.
Okay,
You don't ever get the same number.
is that every time you use the phone, you have a different number or?
Every time you'd have to download it.
Okay, and so once you got your own phone number, did you then delete that Text Now app?
Yes, ma'am.
Okay, and when did you delete that Text Now app?
Oh God, it was back in the end of November,
November of what year?
2020.
Okay. No further questions, Your Honor.
Ms. Hagan, do you have any questions for this person?
Yes, Stephanie,
Let's try not get into any kind of an argument, have a question that can be answered and go that way. All right, go ahead.
Miss Dennis, as I'm a little familiar with the Text Now app, your number gets reassigned. You never get the same number, correct?
You don't ever get the same number. You're right, correct? You don't ever.
So how would these messages come from that number? You confirmed having this number though, right?
I don't ever get the same number. When it regenerates to other people. I
That's
mean, I'm
not what I
sure.
asked. You confirmed having this telephone number, right?
For a week, correct.
For a week. Now, we know your credibility is wonderful.
Your Honor,
Um,
object.
Ms. Hagan, specific questions. You don't have to talk about anything else. You'll get a chance in the closing to make those kind of statements, okay?
Okay.
Go ahead.
So, Ms. Dennis,
Any more questions?
you do know and validate that you did have this cell phone, you have this telephone number.
I
This
don't
was
have
your number at one
for
point.
now, no.
Okay, that's all, Your Honor.
Any redirect, Ms. Tomczyk?
No, Your Honor.
All right. Closing argument, Ms. Hagan, and you'll get to do a rebuttal after Ms. Tomczyk gets to make her closing, okay?
Okay.
Go ahead.
Ms. Dennis admitted to having this number. She claims she had it for a week. Now, we've been through many other PPO violations, as well as this other one coming up that proves she's still contacting. She's denied any sort of involvement in every other violation, including still to this day, considering you found her guilty and there's been a preponderance of evidence to show that it was her. She admitted to having this number. When you get a Text Now number, you don't get that number again. They recycle. You continue to keep that number if you sign in through Google. There's plenty in here that shows that shows it's her without even having to state a name.
All right. Ms. Tomczyk?
Yes, Your Honor. And the fact that the testimony was that Ms. Dennis only had this number for a week was deleted back in November. The court can read through the text messages and indicate this is a person that always calls themselves Adrian. And at best, they thought they were talking to an individual ET, which would be Eric Terracino, which the court indicated is not covered by this PPO. When there's this discussion about Harley, I don't know who you're talking about. Sorry for the inconvenience. All right. They're blaming the fact on the person that has this number is not realizing that the person messaging is not who they say they are. And days later, they forget. Okay. I'm not sure who this individual is or what's going on with it, Your Honor, but there is no proof other than one statement that simply says, "Your Harley," and that's the problem with text messages, Your Honor. There is no support as to say, is that saying "Your Harley?" ? What's it? There's no. It doesn't say "I'm your Harley." It says "Your Harley," and then indicates a text message later. Sorry for the inconvenience. I don't know what you're talking about. Your Honor, this is an individual where Ms. Terracino or Ms. Hagan simply thinks that every time something odd happens, that it must be Ms. Dennis because of what's going on. Ms. Hagan has not provided any proof that this was Ms. Dennis.
Ms. Hagan, rebuttal?
Yep. She says the only Harley, no, she identified herself as Harley Quinn. Your Harley, she continues, when you don't know somebody, you don't continue to text them. Yeah, of course she's using Adrian because she knows she's breaking a PPO. She knows that this is jail time. She knows that she has several more. Now's your only chance. Let's run away and be happy. And then just a couple days after that, she finally gets arrested and then she continues from jail. It's absurd. Your Honor, on this PPO that you signed, I'm actually looking at the original. And this is what I'm not understanding. So if you could please verify for me, because you said that you don't cover anybody under it. You checked in the boxes that you approved for the addendum, the other in relief 5A. When you approved that to cover that, it says, I do not want her contacting my husband in any way as she has a domestic and aggravated stalking charges. She was found guilty and arrested for. If he could be added to my PPO, it would save us from having to file a new one, a new PPO against her from him. You granted that. I'm looking at the PPO, Your Honor.
I never
Which
received that, Your
one
Honor.
is that dated?
Do what?
What date is that signed?
That is signed 3/8/21.
All right, and you're saying there's an addendum?
There is an addendum. It says you checked all the boxes, and under other on page 2, it says see other relief in the addendum. And when you look at the addendum, this is it. It says other from E5A. And that's what it is. So you did mark for him to be covered under
Now,
mine.
are you sure that that's mine? Because the one I'm looking at is dated 3/8/2021, and it just says under other, no following petitioner, no third party contact.
Nope. The next page, Your Honor.
And there is no addendum attached to it, that addendum, and the order doesn't say see addendum anywhere or included in that. The next page is a petition for personal protection order in which you requested other relief in an addendum. That was your request, but I don't usually do that. I've done it a couple of times, thrown some kids' names in there, but I usually don't do that. It's not very common for me to add anybody to somebody's personal protection order. And I don't see it that I did it in this one. You requested it, but the court didn't grant it. Anything
we'll
further
figure
you
that
wish
out.
to say?
Nope, other than it is my phone. It's my phone. It's still third-party contact. It's still stalking, it's still harassment, and it's still continuing. Isabella County, we're gonna file charges here in Isabella County, but because of the rap sheet and the big, long history that is going on in Clare County with her continued harassment, they had agreed to put it up to Clare County prosecuting attorney for you guys to handle this, rather than them filing new charges here in Isabella. That's why the police.
The court's gonna take a short recess and give this some consideration.
Okay.
All right.
All rise, 55th Circuit Court is now in session. The Honorable Roy J. Mink presiding.
May be seated. All right. Recalling the case of Kimberly Lynn Hagan Terracino versus Stephanie Dennis. Court has reviewed the arguments, the paperwork associated with the order to show causes. Court has contacted the probation officer in the district court District Court Probation Office could not confirm that phone number as being Ms. Dennis. Ms. Dennis, though she admits that that was her phone number, she said she no longer had it. And without more, although I think by a preponderance of the evidence, court would conclude that Ms. Dennis was doing it. But the standard is beyond a reasonable doubt. So Ms. Hagan, without sufficient proof that that phone number was hers on those dates, the court is going to deny the motion in order for show cause for contempt. You have another hearing set June 22nd. If you can somehow, and it relates to these messages from that phone number, if you can get proof that that was her phone number or that she had access to it on that date, then it's a whole new ballgame. But at this point, the proof isn't beyond a reasonable doubt. Okay? But Ms. Dennis, if you keep doing this kind of stuff, you think you're so smart, eventually you're gonna get caught. Eventually, you're gonna find a prosecutor that decides they wanna prosecute this kind of stuff. And this could grow into a stalking case with a felony as penalty of 5 years in prison. It's time for you both to grow up. You know, you're both dealing with children. Children need both their mother and their fathers. You have to learn to get along. And that's it. And if you can't do that, you're gonna keep coming back to court and someone's gonna be going to jail. So you're all set. You can sign off.
Thank you, Your Honor.
Thank you.
I know, Ms. Dennis hung up.
When Joe said sign off, she did.
She
She does follow directions.
There you go.
So you just wrote motion to not. Correct.
I usually put motions.
Good morning, Mr. Melton.
Good morning.
Good morning. Sorry for the delay, but both prosecutor and you are in the room. We are waiting for the jail to log back on again.
As soon as I get the jail back.
Tanya Herron, counsel identified for the record.
Sean Brzezis, speaking on behalf of the people.
John Melton for Mr. Heron.
All right. All we're waiting for is Mr. Herron to be put in the room for them to log back in. Anything, either party wishes to discuss about this case before we get Mr. Herron in the room?
I have nothing, Your Honor.
Not that I can think of today, Judge. Thank you.
Mr. Herring, can you unmute your microphone for us, please? Can you hear the court?
Yes,
Thank you.
All right, you are Eric Donya Herron, is that correct?
yes, sir.
All right, today's the date the court set for giving its opinion on motions. First, the motion for bond reduction. Court has looked at the factors that the defendant's prior record, his prior failures to appear in the past, his substance abuse issues, the seriousness of the crimes charged with, all go against him. His employment goes for him, and his ties to the community. What really goes bad is that he violated previous bond conditions. He's tampered with the drug test. He's tested positive. He cut off his tether. He ran from police. So the court's going to, previously had a bond at $250,000 cash surety 10% that was posted. So the court's going to not deny any reduction and leave it as it is. As to the motion to suppress or for an evidentiary hearing, many of the stuff alleged in the defendant's motion were inaccurate regarding the informant, regarding the allegations of connection to a funeral. The case law, both parties cited some case law. They're both applicable, but the case law cited by the prosecutor is more on point. When the court is going to deny the motion based on all the reasons stated in the prosecutor's motion. The informant was named within the search warrant. None of the arguments of the defendant are really applicable in this case. And so the motion is denied. Any questions from either side?
No, thank you, Your Honor.
First, questions, Judge? I have no, I don't think I have any questions, Judge. Thank you.
Do you want to have a breakout room with your client before you
Yeah, it
leave?
looks like he wants to, he may want to talk to me.
All right, we'll put you in the breakout room. We're in recess.
Okay, thank you.
Thank you.
All right, maybe that's our court is not in recess. Mr. Melton, I'm gonna put you in a breakout room.
Okay, thank you.
Uh-huh.
Are you there?
Yeah, we're gonna go in a breakout room. Hold on 1 second.
How long do you want that breakout room for?
5 minutes.
20 minutes, okay?
Five, just 5 is fine.
All rise. 55th Circuit Court is now in session. The Honorable Roy G. May presiding.
May be seated. On case Stephen J. McAnally versus Pioneer State Mutual, counsel identified for the record, please.
Greg Jan on behalf of the plaintiff.
May it please the court, Anthony Costanzo on behalf of defendant Pioneer.
All right, we're here on the second motion for summary disposition. Mr. Jan, you can proceed.
Thank you, Your Honor. The court's previously ruled on the issue of res judicata and collateral estoppel. However, they did not, when you ruled on that, didn't have sufficient information with regard to Dr. Bleiberg and Dr. Hartel. So I believe that your ruling on your previous ruling is the law of the case. And now we're here on the payment of those bills. I've submitted that. I've got affidavits from each provider. And I've read Mr. Costanzo's brief, and a couple things. He is correct. I think this H-wave bill that treatment was not considered as part of the jury's consideration. That seems to be a new treatment since the trial. But that would be the only bill. And again, we've submitted affidavits. These bills were reasonable and necessary. We've submitted the bills. And we're seeking a ruling that they're overdue. Mr. Costanzo filed an affidavit, but clearly the affidavit's hearsay because they say we use ReviewWorks and ReviewWorks says, this is the fee. Well, ReviewWorks is the one to testify to that, not the adjuster. So there is no affidavit to counter Dr. Hartel and Dr. Bleiberg. So, we're asking, because if that's true, if they were agreeing that, ReviewWorks amount is the correct amount, they should have paid that and argued about the remainder. So because they haven't done that, we're asking the court to consider that the payments are overdue and so that interest is owed as well. And, we can subsequently make a motion for determination of wrongful denial on attorney fees.
Mr. Costanzo?
Thank you, Your Honor. Your Honor, first of all, and this might have been on my end, but I don't recall receiving any affidavits from Dr. Bleiberg or Dr. Hartel as to the reasonableness of the fees. My understanding was that this motion concerned whether res judicata or collateral estoppel applied as to the question of whether the treatment was.
The last motion already done that. The only reason I didn't give them full summary disposition is because at that last hearing, you stated you wanted to contest the reasonable and necessary of those medical procedures. And the court remembered that you had done that in your answer or you had done that in your affirmative defenses. Your current responses talks about reasonable and customary. And you've never put that in your answer or defense, affirmative defenses. So the court's not even going to consider that because the court's going to consider that as waived. This case is over 2 years old. I know the court has to share some blame on how long this case has been sitting out there. But if you got anything else to state other than your defense and your brief seems only to talk about reasonable and customary. So if you have anything else to go after, then please state it.
Well, Your Honor, and I apologize to the court, but my understanding was the last motion was relative to the acupuncture. And that the court decided that we had to pay that, but there was no determination made as to what was reasonable and necessary. Or excuse me, I apologize. There was no decision by the court as to whether the fees were reasonable and customary. And this motion.
That's because that issue has never been brought up. Never. In 2 years' time, that issue hasn't been brought up until you filed your brief for this motion.
And Your Honor,
it was never brought up. You never contested it.
Your Honor.
You contested the legality of the chiropractor's fees, and that was it.
Your Honor, you're correct.
And you also made a statement regarding reasonable and necessary, but you've not provided any evidence, affidavits regarding the reasonable and necessary aspect.
Your Honor, you're correct. Let me just explain, and I apologize, and Your Honor, I defer to you, obviously. When this case was filed, the dispute was around a Hoveround that was purchased for $1,600 and a couple of mattress covers and pillows. And so we ultimately paid for the Hoveround and the mattress cover and pillows. I understand that, at least at this point, the jury verdict is res judicata as to the reasonableness, necessity, and relation of Dr. Bleiberg's bills and Dr. Hertel's bills. We've never contested those except for the chiropractic. The issue of reasonable and customary didn't come up because when this case was filed, it wasn't about Dr. Bleiberg or Hertel. It was about the Hoveround and the mattress cover and the pillows. And if that's my mistake, Your Honor, that's my mistake. And I appreciate the court's ruling. That's what happened here. My position is I should be able to at least go before the court as to the question of the reasonableness and customary and whether or not the fees are reasonable and customary. And that's all I'm asking. I understand we don't have any evidence right now before this court that Dr. Bleiberg's treatment's not reasonable, it's not necessary or related. I can't contest that, and I don't. That's why I filed this response. The only question in my mind is what's reasonable and customary as far as the fees go. You're right, though. I didn't bring it up in the beginning because it wasn't about Dr. Bleiberg's bills. It wasn't about Dr. Hertel's bills. It was about the Hoveround and the other thing, and we weren't arguing reasonable and customary with respect to that. And that may be my mistake.
Judge, we've submitted those affidavits that say the services are reasonable and necessary and attach the bills. And that's all the statute requires. Mr. Costanzo's adding an additional word that's not in the statute. He's talking about reasonable and customary. Statute says reasonable and necessary. So reasonableness goes to the bills, necessity goes to the treatment.
Anything else by either party?
No.
No, Your Honor.
Court's going to grant the motion for summary disposition to all charges except for the H-wave, because that wasn't part of the prior treatment, prior trial, and is the only thing that wasn't considered. And but the court will say that the payments are overdue on the others, and therefore interest is to be paid pursuant to the statute.
All right, thank you.
Court will sign an order upon presentation. And Mr. Jan, you can draft that order up.
I will. Thank you, Your Honor.
All right. I guess I'd like the two of you to talk about the H-wave treatment, and if necessary, I guess that we could have a trial just on that issue. But
my hope is we can work that out. So
I would hope so, Your Honor.
okay. You want the court to set another status conference sometime out, or just you'll call the court if it can't be agreed on?
whatever your preference is, you know, we could, you know, set it out at least 60 days, just, you know, give us some time.
Okay, I'll set out a status conference, probably about 75 days out.
Okay, yeah.
All right?
Okay.
Okay. We're in recess.
Thank you, Your Honor.
All rise.